Great. So, Eugene, how does that work then if we're going to the next question, specifically with children, right, under the age of 13 or under the age of 18? Are there differences between what we can and cannot do if it's children involved?
Yeah. So online, well, minors have a lot of rights, especially for online or electronic submissions of photos, or if this was done all electronically. And it probably is. A lot of people are hosting Zoom concerts, right? Zoom studio sessions that are for, sometimes it's for marketing, but even for educational purposes. You can share this content. You should, again, as I said earlier, have a limited release, have the parents sign. But if you are sharing this content online, which most marketing is happening, especially for schools, digital marketing is huge. You want to make sure that you understand the online privacy laws for minors. And there's one that's going to be relevant, and that's going to be, well, there's actually two. There's COPA, which is the Children's Online Privacy Protection Act. And then there is the Minors Eraser Law. And the COPA one needs to just have, in your terms of use, special provisions, special language in there for children, especially under the age of 13, if they're signing onto your website. For the Minor Eraser Law, which is probably the more applicable law here, is if you are sharing images, even if you have a waiver of release, the minor still has rights that they cannot release. I don't think they can release. And that is a right to have their image be taken down. And they can ask for that. And you do have to disclose to them how you shared the image. If it was shared to like a third party, like maybe a digital marketing agency, and the image is residing on their server, and they're using it possibly in promotional content, saying, oh, hey, look, we built this website. And here's the image of the minor. They have to also scrub the image too. So it's really incumbent upon you to really, as a business owner, if you are using minors in any kind of promotional material, just keep a housekeeping, a tracking of where it was being used, where the file's residing, and that's it. Your developer can easily tell you where all those answers, and can easily remove the images also.
So what I'm hearing, Eugene, is that even if there was a photo release being signed for minors, parents can come back and say, actually, I'd like you to remove the image of my child on your website, and you have to comply with that, and also remove it in any other retrospect areas that this photo was in.
Yes, under your custody and control. You can only do so much as a business owner, and the law, yeah. I mean, if this thing goes super popular and gets shared on Instagram amongst a lot of other people, that's a new kind of notoriety, that may be enjoyed by the parents and the child. But if they don't like it, you can only go so far. It's to say, I can only take it down within my control. But these other folks, you may actually have to tell Instagram to take it down. And they do have policies. If you look at their terms of use, they have policies of who to contact if you need to take down an image. Yeah. They make it easy. Try to make it easy for you.
So we just had a question come in that's really relevant too, and that's protection for themselves. So we just have a question here that says, do we need a protection for ourselves too? That if people take images or I believe connect from our website, it goes both ways. So can you talk a little bit about what protections a business should have? I suppose their images are not being taken.
Yeah, so businesses are different, right? Businesses, they don't have fundamental privacy rights in their image and likeness. Those all apply to individuals, to basically people. Businesses have other sets of rights that they need to protect. That's really going to be, well, they need to protect the privacy of their employees and their customers. So to that extent, those privacy rights apply. But the most powerful right actually that you can use to block and cease and desist or demand a cease and desist of use of an image is copyrights and trademarks. Those are really important for a business to really utilize. I would even say trademarks are the most important for service business to use and utilize. Now, right now, at a scale that you're at, it may not make sense. But at some point, when you start to get more visibility, and if you're in a competitive industry, I know with music schools, it's highly competitive. There are a lot of schools opening up every day, right, by different instructors. So trademarks are very powerful, and it's not that costly in the grand scheme of things. They're about $3.95 to file. There are people who will do it for a flat fee. I recommend going to a practitioner. Don't go to LegalZoom. A lot of times, a lot of practitioners have to fix what LegalZoom said, and it may not be 100% bulletproof. So
Okay, great.
trademarks are a good route.